Good morning. May it please the Court. Michael Efferman on behalf of the appellant, George Summers. I'd like to reserve 5 minutes of my time for a rebuttal. I'm hoping to focus my time this morning on the first and third claims raised in the briefs, and of course I'll answer any questions that the Court may have regarding the second claim. I'll begin with the first claim because I think that's the claim that the trial court had the most concern about. I don't think that there's any question in this case that the information is defective because it does omit an essential element from the language of the information. It does not allege that the contact or touching in this case occurred in a lewd or lascivious manner. Now both parties...
But doesn't it reference the appropriate statute, which has all the elements in it, right?
It does, and so I think that refers to what the Florida Supreme Court talked about in the DuBose case.
Correct.
I think both parties have cited to DuBose, and I think DuBose really said two different things. One, the Florida Supreme Court said in DuBose that usually these types of claims must be raised pre-trial, so the state has an opportunity to correct the defect in the information. And second, if the issue is not raised until after the verdict, then as long as, even if the information is defective for failing to have in its language the essential element, as long as it cites to the particular statute, there generally won't be any prejudice and the defendant will not be entitled to an arrest of judgment. But DuBose is different from this case for at least one reason, and that reason is this issue was not raised for the first time post-verdict. Now, it wasn't raised pre-trial either, but it was raised during the trial. It was raised after the state rested, and defense counsel specifically argued that the information was defective because it did not include this essential element of the contact occurring in a lewd or lascivious manner. There was discussion about that. I think the prosecutor below, in essence, agreed that although it cited the statute, the information didn't include that language. The judge even made some reference to the fact, well, I'll tell the jury to make sure that they follow the instruction and not the information. But that instruction was never given. There was no such instruction from the judge that even though you're going to get the information, the elements are only alleged or set forth in the instructions I'm giving you.
Okay, well, if that instruction wasn't given, was that something that should have been preserved below?
Well, I think that what was preserved below is that this was a defective information, and the state had an opportunity to correct it right then. We do know that the information went back to the jury room. The judge said during the hearing on the motion for new trial, this is page 158, that every trial since 1994 he has sent the information or the charging documents back to the jury room. We know under Rule 3.400 it's discretionary for the judge to do so. So in this case, the prejudice is, unlike DuBose where it was being raised for the first time post-verdict, the prejudice is this was a close case regarding lewd and lascivious intent. My client testified that, yes, there may have been contact on the basketball court, but it was incidental or accidental. This jury had to decide was whatever contact occurred, which in the case, in the light most favorable to the state, was for a matter of seconds or maybe only 3 seconds.
So is the prejudice that the information goes back to the jury?
Yes.
Okay, so if the information does not go back to the jury, then what's the prejudice?
I wouldn't be able to argue any prejudice.
Okay.
I could. The information was read to the jury during jury selection. I couldn't find that it was reread at any other point during the trial. There is discussion, or the trial court during the instruction specifically says, you can find the jury or the defendant as charged in the information, So if the jury is back there, and again, the only issue in this case, the only defense even argued in closing argument is this was not a lewd and lascivious touching. It was an accidental or incidental touching. If they're on defense about that and they pick up this information and they say, well, the state has outlined what they must prove in the information. They said to establish this case, all they have to show is that Mr. Summers, touched A.W., touched him in the genitals. The exact language is A.W., who was an elderly or disabled person, by touching the genitals or clothing surrounding them. If they're reading that and they're thinking, oh, that's all that's required, is he touched them in the genitals, then they've established their offense.
Well, knowing that knowing the objections that were made to the information going into the jury instructions, was there a request made to the trial court to give an instruction?
No.
Okay.
The objection in this case was the information was defective.
So no request was made to the trial court to reconcile the information within jury instructions?
No, I mean, the judge indicated he would do so. He didn't.
Well, but doesn't the judge react to what the the attorneys are requesting?
Sure. Well, and again, I think the request that was being made at the close of the state's evidence was this information is defective. The prosecutor seemingly acknowledged that. At that point, the state had an opportunity to correct the information. They didn't. The judge indicated that this shouldn't be an issue because I'll make sure it's clear that the information is just the information and those aren't the elements that they're required to look at. Now, I acknowledge that the elements that were given by the judge were correct, but there was no such instruction, even though the judge said that would be done.
And that was going to be my question, Mr. Hook, because the ultimate instructions that were given to the jury, those were appropriate.
They were correct.
And they followed what the requirements are.
They list all the essential elements. No doubt about that. They correctly told the jury that to find my client guilty, the touching had to be done in a lewd or lascivious manner, but this information does not. And again, there's no dispute in this record. This information went back. I think if there was any dispute, the trial judge resolved that dispute by saying, yes, I think it went back. I've done that in every case.
So the question for us to determine if there's a concession that this was a defective information, so we have to determine whether or not that issue has been preserved, whether or not it wasn't you, but whoever the trial lawyer should have interposed an objection or requested a jury instruction to the jury for the judge to give to the jury, and that we don't have that here.
We have an objection to this information being defective.
Just at the conclusion of the state's case. So
Correct.
is that sufficient to raise the issue? Is that sufficient to preserve the issue? And then we have that, for the analysis, we have to also look at the conclusion, right before the jury was instructed.
Correct.
Whether there was an objection, was there a renewal to that right prior at the end of the entire trial?
There was a renewal to the motion for judgment of acquittal based on the circumstantial evidence standard, which I'll get to in a second.
No, and I understand. No, with respect to the actual defective information.
Well, I mean, I think at that point the judge had denied the
No, I
objection.
understand. No, but my
So
question...
that's the only time that this issue is raised in the trial. I'll be very clear. It came up in a proper, timely motion for arrest of judgment and motion for new trial. But during the trial, the only time this is addressed is when the state rested and defense counsel very specifically argued this information is defective. The state at that point had an opportunity to correct it. They seemed to acknowledge that it was. They could have at that point said, Judge, just to be clear, so there's no issue in this case. Let's go ahead and we'll submit an amended information. There's no prejudice to the defense. They're not arguing they weren't put on notice. We did cite the correct statute. That's not what they're arguing. And therefore, when this goes back to the jury won't be misled. That did not occur, and the judge denied the objection being raised to this deficient information. And I submit this is similar to a teaching moment that this court has used in other opportunities. We see every 2 or 3 years from the DCAs where the courts talk about closing arguments. And they say, the courts almost say, we're required to remind the prosecutors, as we did 2 or 3 years ago, that there's a line you can't cross when it comes to closing arguments. But in this case, we find that the prosecutor did it, and therefore we're writing again so we make sure this doesn't occur. I think the same type of thing can be said in this case. Informations must correctly allege the elements. It wasn't done in this case. It was pointed out to the prosecutor. The prosecutor had a chance to correct it. This information went back to the jury. It's a closed case on lewd and lascivious intent. If we just allow the prosecutors to cite to the statute, and in fact, in this case, if they would have only cited to the statute, my client wouldn't have necessarily even been prejudiced, because then the jury would only be looking at an information that said we charge him under 825.1025.
No, and I understand that, Mr. But I guess the question becomes, I realize what you're saying, that this is for the state to do, but how about with the defense? Was there an obligation to renew all prior objections?
As I stand before you today, my assertion is that it was brought to the court's attention, it was brought to the state's attention. The state chose not to amend the information. The trial court denied the objection. Nothing else needed to be done at that stage. Defense counsel promptly raised the issue. The defense then brought it up again in a motion for new trial and a motion for arrest of judgment. At that point, the remedy would have been give him a new trial. Especially, I think the judge was very concerned about this. This is why the judge granted bail pending appeal. He specifically said this is a fairly debatable issue. I think the judge was worried that you can read the discussion in the motion for new trial hearing. Why is it that you're not charging mens rea in these informations? This did go back to the jury. What if the jury did rely upon this? These are things that, because the rule does allow this to go back to the jury, because many judges do have a practice that they send these back, the state has to get it right. And in this case, when it was brought up, it should have been corrected at the time of trial. At the very least, the judge should have then granted the motion for arrest of judgment or motion for new trial, because this jury may have relied upon the information as opposed to the instructions in finding my client guilty.
I'm curious, Mr., because that's not, I wasn't sure whether this was in the record. Did the judge inform the attorneys of his practice to provide before the jury
Not
is
that I can
given?
see. The only time that I can see a mention of the information going back to the jury is when it was brought up for the first time in the motion for new trial, and the judge said it's been my practice for every trial since '94.
Because I did not see that.
There's no language in the trial that specifically says I'm giving you the information.
So was there any, did the judge explain, and maybe I missed that, but is there a part of the record where it shows that the information did actually go back to the jury?
It doesn't show one way or another. It just, the judge, when this issue was brought up, the prosecutor is the one that said, I don't think that there's any prejudice because the information did not go back. And again, this is pages 157, 158 of the record, and the judge says, judge kind of corrects the prosecutor and says, oh, really? Because I think it did go back in this case. And in fact, every case I've ever had since 1994, I've provided the jury with the information. So in the light of that finding from the judge, and the judge not indicating that he would have done anything different in this case, and I'm sure this court's well aware of this judge, I am as well. I know he's had a number of trials. If he says he's done it every single time since 1994, it's hard to fathom it would not have been done in this case.
So are you saying the motions that you filed preserved the record and that you did not need to request any sort of clarification in the jury and special jury instructions to go back to the jury regarding the information and the elements that were already in the jury instructions?
My position is the defense counsel's argument below that this information was defective was sufficient to preserve this issue. Let me move to the third claim, which I think kind of overlaps with this claim, and that is, did the state's evidence establish the element of lewd and lascivious intent, or stated a different way, was the state's evidence inconsistent with my client's testimony that this was merely an accidental touching? Now, the parties have cited to Knight, or the state cited to Knight, and Knight, the Florida Supreme Court attempted to clarify when the circumstantial evidence standard applies and when it doesn't. I'm not sure it's as clear for everyone now after Knight as opposed to what everyone thought prior to Knight. But what the Florida Supreme Court did say is that the circumstantial evidence standard applies, quote, where the only proof of guilt is circumstantial. I submit in this case, that's exactly what we have. The only thing that would make this conduct illegal would be a lewd and lascivious touching. Accidental touching or contact would not be illegal, would not establish guilt.
But would you agree, when it comes to circumstantial evidence presumes that there's really no other direct evidence. Here, wouldn't you agree there was an eyewitness who saw that? Isn't an eyewitness direct testimony that would take it out of circumstantial evidence?
Direct evidence of contact, but not direct evidence of guilty action. Guilty action in this case can only be if that contact was lewd and lascivious contact. So if the contact, as my client said, was accidental or incidental, then that would not, my client would not be guilty. You can imagine.
You would never have a direct evidence test if we adopt your ruling, because the intent to be lewd and lascivious, only the defendant's going to know what his intent is.
Well, but maybe in this context, but I would say so in a murder case, you have a dead body. You know that a crime has occurred. If the evidence was that the contact occurred for a prolonged period of time, I don't think there's any other explanation that would establish that that's anything other than lewd and lascivious contact. If you touch someone's genitals for a prolonged period of time without any other reasonable explanation, which there would be none unless it's a doctor performing some type of test, that's going to be lewd and lascivious activity. In this case, the evidence was that the contact occurred, according to Mr. Hill, either for a few seconds or 3 seconds. That is susceptible, and under the unique facts of this case, to being accidental or incidental contact on a basketball court. So under these circumstances, I submit the circumstantial evidence does apply. Now, of course, the case law does say...
Yeah, that's a really slippery slope. I mean, okay, so 3 seconds, no. 7 seconds, maybe. I'm trying to figure out where I'm going to draw the line between the need for a circumstantial test or direct evidence.
And I submit under these facts that it's not close. You could get 7 seconds might be closer, 30 seconds, a minute, then you're going to say that's not very reasonable. 3 seconds, I submit that any reasonable person would say that's not automatically telling me that this is lewd and lascivious conduct. It's also consistent, circumstantially, with just accidental or incidental contact on a basketball court.
I don't know, Mr. Because you could imagine scenarios, even 1 second, for a sexual act to take place. So I think the timing is not the issue. The issue here, is it truly circumstantial in the sense that is there any, if we don't have any type of evidence, you're correct, that it would be a circumstantial evidence case. But when you have direct testimony, and this is up to the jury to make the determination as to the credibility and how much weight to be put in it. But I question the fact that if it's 1 second, 2 seconds, I agree with Judge LaRose. I don't think the timing is an issue here.
And Your Honor, I respectfully disagree. I think in a situation where you have 1 or 2 or 3 second contact, that's consistent with the defendant's reasonable hypothesis of innocence, and that's the only evidence of guilt in the case. Because, again, my client's on the basketball court, the alleged victim's on the basketball court, the contact occurred, my client has established that. It's only a crime. And again, if you apply just the language from the Florida Supreme Court, the other quote, where all the evidence of a defendant's guilt, i.e. the evidence tending to show the defendant committed or participated in the crime is circumstantial. In this case, the only evidence of his guilt is whether or not this was a lewd and lascivious touching.
Okay, let me take it to the extreme to follow your thing. If someone would run up, grab somebody's genital, take like 30 seconds, and then leave under your scenario, ooh.
30 seconds?
It could be 1 second to go and to grab somebody's genitals and then, so that's why you can't. You can't do it that way.
But again, the way you just described that, reasonable people are not going to say that that's incidental contact. What you described is not incidental contact.
Well, we have an eyewitness. We have an eyewitness in this case that testified
Before-
accordingly. That testified accordingly. The jury gets to make a determination, and this is direct eyewitness, direct evidence. And if there's any direct evidence, by definition, it's not circumstantial evidence. That's what I'm trying to.
No, I understand, Your Honor, and I'm doing my best to convince you, and I may not be able to, but the argument is that under these very unique circumstances, that this is just as likely incidental or accidental contact as it is.
That's not how it was described in the testimony. It didn't say that they brushed up against or that they touched. It was a
cupping action.
Well, it's described as a grinding motion.
Grinding from behind. I'm not sure. The grinding from behind, I don't know how much the state's relying upon that for the charge in this case. But you can, again, imagine in basketball, I can watch a basketball game on any given night and I see someone guarding someone else who may be grinding from behind. So then the other action is reaching around and cupping someone's genitals for a matter of either 3 or a few seconds, is the way the testimony came out from Mr. Hill.
Ms. Crawford, excuse me, you're up to 17 minutes. So
Thank
you use your time as you wish. But
Thank you. I will reserve the rest of my time for rebuttal.
very good. Thank you, sir.
May it please the court, counsel. My name is Laurie Benoit-Knox, and I represent the state of Florida in this matter. Starting with issue 1, as appellant pointed out, yes, they did in the judgment of acquittal argue that the information was defective. However, the argument, I see this as 2 separate arguments. The argument that the information was defective was waived because it was not raised pre-trial. It was raised at the point of JOA when it would have been a gotcha that the Du Bois case cautions against. It was too late at that
Wouldn't you,
point.
at that point, if that motion was raised, that objection was raised, typically what happens, the prosecutor, oh, judge, may I amend the information, and that's usually is done. But here, when you have a concession by the state that it is defective, nothing has been done, and then to compound it further, that the jury now gets to see that, why isn't his point well taken?
Well, I agree, Your Honor. It would have been a lot better, and I would have liked it if they had amended it. Now, if they had amended it, though, it wouldn't have changed the analysis, because at that point, what we're looking for is whether the defendant was hindered in his preparation for trial. That's the only reason when it's raised at the JOA time that it can be dismissed per the rule. And at that point, it's clear that he knows exactly what he's being accused of. He's also not in danger of double jeopardy, of being accused again with the same incident. So while amending it would have avoided the issue of the jury seeing an information that's missing some element, it wouldn't have changed anything as to the preparation for and the notice that the defendant was on. And that's really what a defective information is supposed to be dismissed for. So I would submit to you that these are 2 separate arguments. What counsel is really arguing as to reversible error is the fact that the information went back to the jury, not the fact that it was defective. And by the way, the state never really conceded that it was defective. It conceded that the elements were missing. However, we absolutely...
How is the jury supposed to, I mean, they are not provided statute books in the deliberations, and you would agree that the only way that all of the elements are there is by the statute. Is that right?
I agree, Your Honor.
Okay, and so if the jury is given instructions by the judge that, hey, the information here is exactly what the defendant's been accused of, or that you may find the defendant guilty as charged in the information, so what is the jury to do when they have that information and then they have jury instructions that have different elements?
Right, and I understand the concern. However, because the information is not a document that must go back to the jury.
But it did, correct?
So whether it did is actually, the judge says, I always give it, so I'm assuming I gave it. Defense counsel is the one who says, I remember seeing it go. This is how we know it went. At that point, defense counsel should have objected to the information going back. Because defense counsel did not object, this court can only review the error for fundamental error. And I would submit it's not fundamental error because the jury instructions were correct. They were given out by the judge. They were orally. They were given out in writing. Additionally, throughout the trial, from the voir dire with the jury veneer, the judge says several times, the information is not the law. I will instruct you on the law. The information is not evidence. It doesn't prove guilt, even though it does say. And information is not something the jury should rely on, and he says that.
Yeah, and can't we assume that the jury followed the instructions?
Exactly, Your Honor. The case law, Florida case law says that absent of showing in the opposite, we assume that the jury followed the jury instruction.
But nonetheless, in this case, the judge arguably created confusion by sending back correct instructions with the defective information.
Your Honor, I don't believe that it created confusion, and I certainly don't believe that appellant has met its burden that is a fundamental error. As to issue 3 with the JOA for sufficiency of the evidence, it's not a circumstantial evidence case. There's an eyewitness. The eyewitness says that he saw 2 things. He saw a grinding motion from behind with appellant's genitals touching the child's buttocks, and the appellant's arm going around the child and grabbing the child's genitals in a squeezing, cupping motion. The 2, yes, there's a basketball court. However, the fact that both of these events are observed shows enough that there was an intent of looting lascivious. Additionally, the intent is a factual determination to be made by the jury. So the state would argue that the trial court did not err in denying the judgment of acquittal, even if this court were to believe that there was a reasonable hypothesis of innocence that should be considered. Even that was rebutted. The mother says he can't dribble, he can't run, he can't be guarded. When we're talking about him playing basketball, all he does is shoot hoops, then go get the ball and shoot hoops again. The hypothesis that he was being guarded and engaging with somebody in a real one-on-one game is rebutted by other testimony that he's not capable of doing that. So if there's no further questions, I would rely on the merit of the state's brief and ask this court to uphold the conviction. Thank you.
Thank you, Ms. Benoit-Knox. Mr. Rufferman?
May it please the court, I've learned not to stick my hand in a beehive twice. I'll stay away from claim 3 and focus on claim 1 in my rebuttal. I'll be very short and sweet. On page 244, one of the last things the judge said, despite whatever other arguments were made about this is the information, it's not evidence, one of the last things the judge said is the bottom of page 244, you may find the defendant guilty as charged in the information or not guilty. If they're taking that to heart, and they're going back, and they're on the fence about whether this was lewd or lascivious conduct on behalf of my client or simply incidental contact, and they're saying, well, let's look at the information. That's what the judge told us to do. We may find him guilty as charged in this information, and under this information, all we have to do is find that he touched the genitals. And if they were misled by that, and again, my client acknowledged there may have been incidental contact with the genitals, but if they think that that's enough because that's all the state alleged, because the state failed to allege an essential element in the language of this information, my client at least deserves a new trial. If the issue is that the jury shouldn't have been exposed to that defective information and that could have caused them to come back with this verdict, usually sometimes in a judgment of acquittal or arrested judgment, maybe the remedy would be to set aside the conviction and grant a judgment of acquittal, but at the very least in this case, my client should get a new trial so the jury goes back in the jury room without a defective information.
But if it was known that the information that is defective was going back to the jury, why wasn't an objection made at that time? Shouldn't an objection have been made at that time?
All I can say, Your Honor, is defense counsel, I think, thoroughly argued that this information was defective. It was acknowledged by the state that this language was missing. The state had an opportunity to correct it, and no correction was made. And at that point, the information still went back to the jury.
But the information isn't required to go back.
I agree.
It's discretionary by the trial court, correct?
I agree. And once it was pointed out in this case that it was defective, it should have been corrected. The state had an opportunity. Unlike a case where it's being raised for the first time post-verdict, the state could have corrected this error. And if there's any question, if there's any possibility with the state having some harmless error standard that this could have affected this verdict, my client should get a fair trial where when the jury goes back to the jury room, they're only looking at a correct set of instructions and a correct information that charges the essential element of the lewd and lascivious conduct. The contact must be done in a lewd and lascivious manner. I'd ask the court to reverse and give my client a fair trial. Thank you.
Thank